The last order.
Yes.
On the last date, my lord, the lordship was pleased to continue the interim order and lift this case, my lord, after 2 weeks. In fact, my lord, that order expired before the my lord date fixed.
Yes.
Lord, this matter may be heard, my lord, finally on any date. In the meanwhile, my lord, there is one application which is pending.
Yes.
The petitioner number one, my lord, died during pendency of this, my lord, petition.
डिसाइड हो
Decide on
नाम जुड़ गया ना
11078.
11.
078. Okay.
हाँ पहले हो चुका नाम है डिलीट हो गया उससे दूसरा
अगर हो गया तो फिर तो ठीक है. My noting says that it is pending.
पेंडिंग शो कर रहा है.
Deleting.
Status में से pending शो कर रहा है. कौन सा ऑफिस है?
When it is decided, application.
सर
Because the High Court may not site shows that it is pending.
When you filed application,
That is well on in
19.
2019. 6/9/19.
6/9/90.
In fact, not I have also not noticed that here. Yesterday, when we took the printout of Millard from the website, then it was noticed that it is pending.
Not decided. इस पे तो application पे लगा ही नहीं है कभी.
It was never listed. Millard.
Petitioner has filed application IA number 11078 of 2019, application for deletion of name of petitioner number 1 from array of petitioners. Full stop. It is submitted that Shri Dev Prakash Joshi expired on 23/5/19. Legal hires of said petitioner is on record.
No, there is no question of legal here. It is a service matter, Millard. No legal.
In view of same, writ petition stands abated in respect of petitioner number 1. Yes, when you will argue?
Whenever your lordship, because I am Millard raising two more points, Millard, I will inform him what I am arguing actually. Because the section 10(1) says that it will be by order, state government will make a reference. Article 161 applies. Two things, Millard, that it is not, Millard, reference is not passed by the state government first. It is by, Millard, Assistant Labor Commissioner. And the second, Millard, it is not in the name of
If you are
government.
ready, we can hear it. You are ready?
सर yeah, I am ready sir.
Yes. That is 16 matter.
Yes sir.
But the respondent of Millard 1,
Yes.
he Millard made a request. He was Millard under the Millard employment of Millard company.
Yes.
If your lordship comes to Millard, page 26. I will start from here, Millard, that Millard, in fact, the reference and the application is
Yes.
not maintainable because it's a, he was employee of the company.
Yes.
And the petition is filed, Millard, against the Millard persons, Millard, and what is the status between the two, Millard.
Yes.
If your lordship comes to Millard, page 26.
Idea क्या है? Yes. Yes.
He was appointed, Millard, as a manager, renewable energy.
Yes.
Page 26, Millard, 23rd January 2015.
Yes.
Then if your lordship comes to Millard, page 28, he could be, Millard, its services could be terminated, Millard, giving two months services, Millard.
Yes.
That is, Millard, clause 10, separation.
Yes.
Your services can be terminated by giving 2 months notice or salary in lieu thereof.
Yes.
Then if lordship comes to Millard, his
Yes.
biodata, which he himself has furnished, Millard, page 34.
Yes.
It
Yes.
says, my lord, this is BE Mechanical Engineering. Summary of professional experience. Presently working as a manager. Earlier also, my lord, he was working as a manager. Liaison and corporate affairs with the Murphy government.
Yes.
This is the, my lord, he has submitted for employment.
Yes.
Then if lordship sees, my lord, page 40.
Yes.
His services were, my lord, terminated under clause 10(1), my lord, which I have laid out to your lordship.
Yes.
Then he raises a dispute, my lord. The initially, my lord, it is taken up by, my lord, संसाधन अधिकारी क्या बोलते हैं? If lordship sees, my lord, page 45.
Cancellation.
Yes.
Conciliation officer,
Page 45.
page 45.
Yes.
For conciliation. We specifically raised objection, my lord. If lordship sees page 46.
Yes.
This is his application, my lord. Application of the employee to the assistant commissioner, and what he says, dear sir, I joined Adani Group, manager renewable, है ना, भोपाल location, and his work was, my lord, for government licensing in renewable energy.
Yes.
One of the point is, my lord, that he is not workman. Therefore, I am showing this, my lord.
Yes.
We filed, my lord, a very specific and detailed, my lord, objection at page 48.
Yes.
The paragraph 1 says specifically that the present conciliation proceedings are outside the purview of this matter of the termination simpliciter given by the management as per terms and conditions of the appointment agreed upon between the employee Deepak Chansoria, who was performing managerial function, thus was not an employee covered under the ID Act. This was our, my lord, specific, my lord, objection. Then we have given, my lord, his salary that he was getting, my lord, 1,16,000.
Yes.
667. This is not in dispute. As a manager, and this is, my lord, per month, and the yearly was, my lord, 14 lakhs rupees. Paragraph 3, being a managerial cadre officer, he falls out of purview of the definition of the workman. This is our specific objection.
Yes.
His salary, my lord, if your lordship sees, my lord. Salary का publication. Salary
Number
detail.
52.
Salary detail is also, my lord, here.
Page number 50.
पेज नहीं नहीं, वो तो वो है पिटीशन. Page 33.
Yes.
This is with the appointment, my lord.
Yes.
This is, my lord, the basic. Then house rent allowance, medical reimbursement, meal voucher, LTA, uniform maintenance, car and automotive. He is given, my lord, the facility of that also.
Yes.
Other allowances, bonus, provident fund, gratuity, so and gross remuneration is 14 lakhs. So he was given all the facilities, my lord, which is not given, my lord, to the managers. Then, my lord, matter is taken up, my lord, and then a reference is made. Matter is, my lord, taken up for, my lord, reference. If your lordship sees, my lord, page 53.
Yes.
Page 52, your lordship may see first. When he makes an application, what he does, my lord? He makes, my lord, respond number, my lord, 1, 2, 3, 4, 5, who are either the madam chairman or, my lord, the director or the managers, etc. But he doesn't make, my lord, the company a party.
Yes.
Employer. My lord, just to save time, my lord, I will just show one judgment. 1970 Supreme Court. What is the position, my lord, with regard to the company? This is, my lord, a constitution bench judgment of 1970. Page is, my lord, page 82.
Yes. 1970.
1970 Supreme Court, page 82. Judgment दिया नहीं करनी. And your lordship may just note, my lord, there is another judgment, my lord, in the same volume. That is, my lord, R.C. Cooper's case. That is 11 judges judgment, my lord.
Yes.
That is AIR 1970 Supreme Court 564. That is by 11 judges, my lord.
Yes.
Now here, my lord, this case was, my lord, where The 100% Milord share was Milord in the name of the Milord president.
Yes.
There dispute arose with regard to the claim
1970.
70 82
82.
82.
Yes.
Dispute arose Milord with regard to the Milord payments. That claim was made Milord against the Milord president and the government.
Yes.
The Supreme Court then has occasion to consider Milord this legal position, and based upon Milord an earlier judgment of English court Milord in Simon versus Simon, the Supreme Court in paragraph 4 Milord concluded this. Page 85.
Yes.
Before considering the authority cited by counsel before us, we proceed first to examine the meaning of the words used by Parliament in the definition clause of appropriate government. Here, my lord, also it is appropriate government, my lord.
Yes.
It is an undisputed fact that the company was incorporated under the Companies Act, and it is the company so incorporated which carries on the undertaking. Undertaking, therefore, is not one carried on directly by the central government or by one of the departments, as in the case of posts and telegraphs or the railways. It was therefore rightly considered both in the High Court as of before us that it is not an industry carried on by the central government. Your Lordship, my lord, just then on the same paragraph, my lord, your Lordship will find these kind of lines, my lord.
Yes.
After this, my lord, line,
Yes.
your Lordship will find, can the respondent company, 10, 11 lines, my lord.
Yes.
Can the respondent company, therefore, your Lordship got it, my lord?
It is, there is clearly a relationship of principal and agent.
Yeah.
Then
There clearly arises in such case the relationship of a principal and agent. The words under the authority of means pursuant to the authority, such as where an agent or servant under acts or pursuant to the authority of his principal or master. From here, my lord, it is important.
yes.
Can the respondent company therefore be said to be carrying on its business pursuant to the authority of the central government?
Yes.
That obviously cannot be said of a company incorporated under the Companies Act, whose constitution, powers and functions are provided for and regulated by its Memorandum of Association and the Articles of Association. An incorporated company, this is very important, my lord. An incorporated company, as is well known, has a separate existence, and the law recognizes it as a juristic person, separate and distinct from its members. This new personality emerges from the moment of its incorporation, and from that date, the person subscribing to its memorandum of association and others joining it as members are regarded as a body, incorporate, or a corporation aggregate, and the new person begins the function as an entity. Now, Your Lordship may kindly turn to me on the next page.
Yes.
Its rights and obligations are different from those of its shareholders. Action taken it does not directly affect its shareholders. The company in holding its property and carrying on its business is not the agent of the shareholders. So the law propounded is that the company itself is a juristic person. Directors, members, shareholders, they have entirely a distinct entity.
Yes.
Kindly see the next judgment in the same volume. Just to save time, if your lordship can straightway turn to paragraph 13 at page 584. This is by 11 judges, my lord.
Yes.
R.C. Go. This is a famous, my lord, R.C.
Yes.
Cooper's case, my lord. Page 584,
Yes.
paragraph 13.
Yes.
A company registered under the Companies Act is a legal person, separate, kindly underline this, my lord.
Yes.
Separate and distinct from its individual members. Property of the company is not the property of the shareholders. A shareholder has merely an interest in the company arising under its article of association, measured by a sum of money for the purpose of liability and a share in the profit. Again, a director of a company is merely its agent for the purpose of management. They
Yes.
say it is agent, but only for the purpose of management, nothing more.
Yes.
On this basis, my lord, I say, my lord, that if he was employee of the company, my lord, then he should have initiated everything against the company. He cannot, my lord, by making the chairman party, my lord, director party, or my lord, the manager's party, my lord, maintain an action, my lord, under the law.
Yes.
Your lordship knows, my lord, the directors, my lord, under the companies are, they are, my lord, they change, my lord, by rotation. They have to be elected, my lord, by the shareholders, and they have a fixed tenure. And they get, my lord, an amount, my lord, as a remuneration for performing the, my lord, job of director. They are, my lord, also, my lord, in fact, my lord, they are working for the company. Maybe that they are, my lord, elected from the shareholders, and there can be, my lord, independent directors, my lord, like professional directors who have nothing, no interest in the company.
Yes.
So this was not maintainable, my lord. The second thing, my lord, if lordship sees, my lord, all these objections were taken, and then, my lord, a reference is made. Kindly see, my lord, the reference. Page 57, my lord, just before, my lord, the reference.
What about his status as workman?
My lord, while making a reference, my lord, he says he is a manager. This is what I'm going to point out.
So what was said in award?
No,
कोई
my
अवार्ड
lord.
पारित नहीं हुआ इसमें?
Award, we have challenged it on the ground of jurisdiction, my lord.
Yes. Yes.
When, my lord, it is taken for reference, we again, my lord, read page 57, all detailed objections
Yes.
that he is not a workman.
Yes.
He is not covered by that. But the reference is made, my lord, ignoring all this.
Yes.
Kindly see, my lord, page 61, the reference order.
Yes.
Two things are here, my lord. I will deal with it, my lord, one by one. How it reads, my lord. This is passed, my lord. Order is passed by Upshramayukt.
Yes.
What he says, चूंकि मेरा यह मत है. So, opinion of, my lord, the deputy commissioner.
Yes.
कि सेवानिवृत्त दीपक चंसोरिया सो एंड सो कोलार रोड पार्टनर डिप्टी जनरल मैनेजर अदानी ही हिमसेल्फ इज सेइंग, my lord, डिप्टी जनरल मैनेजर अदानी रिन्यूएबल कार्यालय सो एंड सो में एक्सटेंशन सो एंड सो में मध्य अनुसूची में निर्देश में औद्योगिक विद्यमान है. चूंकि औद्योगिक विवाद अधिनियम की धारा 282 के अनुसार औद्योगिक विवाद के लिए काइंडली अंडरलाइन ही हिमसेल्फ सेज राज्य शासन उपयुक्त शासन है.
Yes.
चूंकि मैं मींस डिप्टी कमिश्नर उक्त विवाद अधिनिर्णय के लिए भेजना उपयुक्त समझता हूं, अतः मैं उपश्रमायुक्त भोपाल औद्योगिक विवाद अधिनियम सो एंड सो की धारा के अंदर मैं रेफरेंस करता हूं. टू थिंग्स. दिस इज नॉट ए रेफरेंस मेड बाय द स्टेट गवर्नमेंट. This is a reference made by Deputy Commissioner.
Yes.
Second, the reference order itself says that he is a manager.
Yes.
Kindly see, my lord, section 10. Workman's definition, my lord, it clearly says, my lord, if you are in a managerial post, that is defined under section 2, clause S.
Yes.
Section 2, clause S. And this has been decided in many cases, my lord.
Yes.
Who are excluded are, my lord, the clause 3 at the last, but does not include any such person, then 1, 2, 3, who is employed mainly in a managerial or administrative capacity. These are the exclusions. Now kindly see, my lord, section 10(1). Constitution.
Yes.
Where the appropriate government
Yes.
is of opinion that any industrial dispute exists or is apprehended, it may and at any time, kindly underline, by order in writing.
Yes.
Make a reference. So this says it is by appropriate government by order in writing.
Yes.
In this case, my lord, so far as, my lord, this point is concerned that the appropriate government is a state government, there is no dispute. The reference order also says that it is the state government.
Yes.
But can it be said to be, my lord, an order by the state government? Kindly see, my lord, section 1, article 161 of the constitution for a moment. It says, my lord, that every order of the state government has to be expressed in the name of governor.
Yes.
And then there is a authentication. Then the authentication can also be only to the secretary, my lord, not to anybody else.
Yes.
Now there is a direct constitution bench judgment, my lord, 63 Supreme Court, which has been followed later, my lord. I have not brought the later judgment because this is being followed till date. Page 395, my lord. वो हमारी वाली किताब कहाँ है? तुम लोग ने ये काम बहुत गलत करते हो। हमारी वाली किताब निकालो इसमें तो।
Lordship, I apologize to interrupt your Lordship. We are the adjudicating authority, and as per my information, no reply has been filed by the state. Before hearing the matter finally, your Lordship.
Only legal questions are.
Yes, your Lordship.
क्या जरूरत है रिप्लाई का? अभी देख लीजिए आप.
दे दिए.
Lord, paragraph 9, my lord.
Yes.
My sincere apologies, my lord. In fact, I marked in my book and you have not the paper. The question, therefore, is whether he did, in fact, make such an order. Merely writing something on the file does not amount to an order. Before something amounts to an order of the state government, two things are necessary. The order has to be expressed in the name of governor as required by clause 1 of article 166, and it has to be communicated. As already indicated, no formal order modifying a decision of the revenue secretary was ever made. So this is, my lord, the requirement that it has to be in the name of governor. Then, my lord, paragraph 10. The business of the state is a complicated one that has to be necessarily to be conducted through the agency of the large number of officials and authorities. The constitution therefore requires, so did the rules of business framed by the Raj Pramukh of PEPS to provide, that the action must be taken by the authority concerned in the name of the Raj Pramukh. It is not till this formality is observed that the action can be regarded as that of the state or here by the Raj Pramukh. We may further observe that the constitutionally speaking, the minister is no more than an advisor, and that the head of the state, the governor or Raj Pramukh, is to act and in the aid and advice of the council of ministers. Therefore, until such advice or is accepted by the governor, whatever the minister or council of ministers may say in regard to the particular matter does not become the action of the state until the advice of the council of ministers is accepted or deemed to be accepted by the head of the state. So this is the procedure, my lord, which is to be followed. Now just to point in one line, my lord, neither there is a provision, my lord, under the statute for delegation of powers, my lord, nor it is to anybody's case that power is delegated, my lord, to that, my lord. And there is no provision. So this cannot be, my lord, said to be, my lord, a reference made by the state government.
Yes, respondent.
सर एनेक्चर P13 में जो स्टेट गवर्नमेंट को 12(5) के तहत सेक्शन 12(5) के तहत पावर दिया है सर. इसको रेफरेंस को लेबर कोड में डिसाइड करें एंड देन लेबर कोड ने इश्यूज फ्रेम करके जो ऑब्जेक्शन है, जो इन्हें यहाँ ऑब्जेक्शन लिया है सर कि कंपनी को पार्टी नहीं बनाया थे, उनके रिप्लाई में वहाँ कहीं भी ऐसा
What is 12(5)?
Can not before can I just give one more judgment?
Yes.
That at the time of reference, my lord, this has to be adjudicated, which has not been done, my lord. It's a, my lord, direct judgment of 2000, volume 3 SCC,
Yes.
pages, my lord, 93.
Yes.
Relevant is, my lord, paragraph 8, 10, 11, 12, 16 and 17. Material has to be considered, my lord.
Yes.
Paragraph 8, my lord, the Supreme Court has quoted, my lord,
Yes.
where the, my lord, government has, my lord, refused to make a reference, taking into consideration, my lord, the basic pay scale and the nature of duties. After examination, it reveals that you were first appointed as Assistant Secretary Indian Tea Association, and subsequently promoted to the post of Joint Secretary. Besides the basic pay, you are given child allowance, house rent subsidy, like in this case, my lord, furnishing allowance, house maintenance allowance, transport subsidy, reimbursement of fuel and electricity charges, entertaining expenses, reimbursement of servants' wages, monthly club subscription, leave travel allowance, and the reimbursement of the hospital expenses. Your duties also included power of sanction and expenses on behalf of the Indian Tea Association. So your pay and prerequisites and the status enjoyed by you in the organization and also the power of sanction of expenses suggested as you were a part of the management. Hence, you cannot be treated as a workman within the purview of the Industrial Disputes Act. By saying this, my lord, the state government, my lord, after considering the material, refuse, my lord, to make a reference. Then kindly come to the paragraph 10. Before making a reference under section 10 of the Act, the appropriate government has to form an opinion whether an employee is workman and thereafter has to consider as to whether an industrial dispute exists or is apprehended. In the present appeal, we find that the state government rightly approached the question whether respondent number 1 was a workman. Unless this condition is satisfied, no reference can be made. From the order of the state government, we find while deciding the question whether respondent number 1 was a workman, it took into consideration the salary and allowance of respondent number 1 drawn at the relevant time and also the nature of work. Respondent number 1 who has appeared in person did not dispute the salary and allowance, etc. So this has to be considered, this was considered, and therefore kindly say below paragraph 16 and 17. The paragraph 14, the last line we say, we therefore hold that the above administrative order was passed by the state government after taking into consideration the material available on record and it could not be faulted. So they have to consider the material. Paragraph 16. Thus it appears that in the case of question required detailed investigation in view of the voluminous evidence sought to be adduced, but it is not so in the case in hand. Therefore, the above decision is not relevant for our purpose. The ratio laid down by this court squarely covers the appeal and it does not appear from the order that the state government took into consideration any irrelevant or foreign material. Then paragraph 17, last 4 lines. Inasmuch as it was for the post of assistant secretary to which post respondent number was initially appointed, but subsequently he was promoted to the post of joint secretary. That apart, we are concerned with the actual duties performed by the respondent number 1 at the time of dismissal from service, which we have already indicated and we are also taken into account by the state government. And therefore, my lord, that
Yes.
SLP was dismissed. And
Yes.
these materials were, my lord, and the submissions were not considered by making reference, my lord.
सर पेज नंबर 21 में इनका रिलीफ क्लॉज जो किया है टू इशू द रिट इन द नेचर ऑफ द सर्कमस्टेंस इन एनी अदर अप्रोप्रिएट रिट ऑर्डर डायरेक्शन रिक्वेस्टिंग द इम्प्यून ऑर्डर एनेक्सर P13 जिसका रेफरेंस लेबर कोड में पहुंच गया सर. अब रेफरेंस के में इनने जो आपत्ति ली है कि जो इमेंटेबल नहीं है, तो वंस रेफरेंस यदि चला गया है तो मेक द इशू तो हार्नेबल हाई कोर्ट का अपना फुल बेंच है सर. यदि कोई रेफरेंस यदि लेबर कोर्ट में है तो डिसाइडेड इन मेरिट ऑन मेरिट सर. तो वी हैव गिवन द कॉपी. उसमें रिप्लाई में भी लिखा है मैंने.
Yes. इस पे रिलाई कर रहे हैं आप पैरा.
सर ये इसमें प्रिंटिंग पैरा नहीं आया. द एक्ट कैन बी क्यूज्ड बाय द वेयर द इंडस्ट्रियल हैड बिकम अ स्लाइड डिड नॉट अराइज द डिसीजन. वी may not note the decision in which the Supreme Court has to consider the pre-state industrial dispute or the holding and the order reference to the bed.
पैरा बताओ.
रनिंग कह रहा है, इसमें नहीं आया है। अंडरलाइन है सर।
into 40 days duration. पेज बता दो, पेज नंबर कहाँ पर दिखा दिखा दो।
फिर 12(5) का भी सर इसमें पैरा 11 में, द प्रॉब्लम विच द गवर्नमेंट हैज to be considered while the under section 12(5)(a) whether there is in case for a reference. This is the expense means the government must consider whether a prima facie case for the reference has been made on the merit.
It says that order passed by appropriate government cannot be interfered with.
Sir,
Petitioner is saying that reference order has not been passed by appropriate government
एप्रोप्रिएट
itself.
गवर्नमेंट की सर डेफिनेशन दी है कि जो लेबर कमिश्नर यहाँ से कैंसिलेशन ऑफिसर को भेजता है, देन वो जो उपायुक्त या समायुक्त जो है आयुक्त कमिश्नर महोदय, वही इसको रेफरेंस करते हैं सर। जो अभी तक होता आ रहा है कि जो यहाँ से सेक्शन 10 के तहत लेबर कमिश्नर कैंसिलेशन आदि के तहत सेक्शन 10 या 2A के तहत एप्लीकेशन मूव करता है, देन वो जाता है इंदौर या भोपाल, वहां पर लेबर कमिश्नर जो अथॉरिटी जो गवर्नमेंट ने बनाया हुआ है वहां से रेफरेंस करके वो देता है। यदि कैंसिलेशन समझौता या नहीं हो पाता, देन वो मेक द रेफरेंस, और कोर्ट ने रेफरेंस किया है और ये बोल रहा
You
है
have to show in accordance with law that deputy labor commissioner was acting acting on behalf of governor as appropriate government.
कि सर इसमें डेफिनेशन फर्स्ट में आई है गवर्नमेंट मींस,
Yes. कहाँ पढ़ रहे हैं आप?
ये सेक्शन 1A सर,
1A.
फॉर आईडी
1A.
सर।
Yes.
Clause 2. Clause 2 will be applicable.
1A.
Section 2A
Yes.
और स्टेट के लिए clause 2. One is for center.
And sir,
State के लिए
in
two.
relation to any to
Just a minute. Yes. 2A. 1.
two sir,
2. Yes.
in relation to any other industrial dispute.
कहाँ पढ़ रहे हैं आप? 2A2 is notwithstanding anything contained in section 10.
Section 2 definition.
Definition applicable.
अच्छा, section 2
Section
definition.
Section 2 definition.
Clause 2.
Section 2, in fact, 2A, this definition shows who is the appropriate government.
Yes.
For what.
Starting.
Section 2, there are A.
Yes.
In A, there is clause 1 and clause 2. So, Roman clause 1 is small, Roman clause 1.
Yes.
Clause 2 will apply.
Yes.
In relation to any other industrial dispute, including the state public sector undertaking, subsidiary companies set up by the principal undertaking and autonomous bodies owned or controlled by the state government,
Yes.
provided that in case of dispute between the contractor and the contractor labor employed through the contractor in any industrial establishment where such dispute first arose, the appropriate government shall be the central government or the state government as the case may be, which has control over such.
Yes.
That is only an exception, but it speaks about the government only. One is, my lord, with regard to the central government, and there is no provision, my lord, which my lord speaks about delegation. Your lordship knows, my lord, the law. Unless there is a statute gives power to delegate, the power cannot even be delegated.
Yes.
And even if my lord, under the procedure, my lord, if the deputy commissioner has been or commissioner, my lord, has been authorized, you first examine. Then also, my lord, it has to be in the name of the governor.
Yes.
By the secretary, he can only examine and then forward the papers to the government. That the prima facie, this is my finding, now you take the decision, and the government will take the decision. And when the government will take the decision, then it has to be expressed in the name of governor. This is the settled law, my lord.
Yes.
अभी अपना एक आर्गू किया था ना जो डिवीजन बेंच में PIL, उसमें भी सीरीज आपके जो ऑर्डर निकाले. There is a recent judgment also, my lord, I will just apply. recently argued before the division bench,
Yes.
Yeah,
where it was said that every order, my lord, doesn't become the order of the state government.
Yes.
sir. देन फिर सेक्शन 4 में कैंसिलेशन ऑफिसर, देन सेक्शन 5 में बोर्ड ऑफ कैंसिलेशन.
Yes.
The appropriate order may the occasion arise by the notification in the officer gazette committee of board of the cancellation for the promoting of the settlement of an industrial dispute. Section 5, sir. The
Yes.
board shall consider the chairman and the two or four other members as a appropriate government think fit, that the chairman shall be independent person and the other members shall be appointed in the equal numbers to represent the parties to the dispute, and any person appointed the respective party shall be appointed on the recommendation of the party, provided if any party fails to make a recommendation of the within the prescribed time, the appropriate government shall appointed the such person to the fifth.
There are two more points to be satisfied. ये
Sir.
तो एक तो आप अभी बता नहीं पाए गवर्नमेंट वाला.
जी.
Second is you have not implemented necessary party, and third is he is not workman as he
सब
is managed.
वर्कमैन के लिए देन इश्यूज बना हुआ है सब वहाँ पर लेबर फोर्स में, और ये जो 1,40,000 के इन्हें खुद 40
And authority has not considered the points which has been raised by petitioner.
सर, इनका रिप्लाई में ये पॉइंट लिया है अपने सर.
ये इनके ऑर्डर में रिफ्लेक्ट होना चाहिए ना, हाउ दिस पॉइंट्स आर डेल्ट विद बाय द अथॉरिटी.
इनका सर रिप्लाई जो है, जो ये पॉइंट यहाँ रेज कर रहे हैं सर, वहाँ पे एक्चुअली रिप्लाई एनेक्सर P7 सर, जो वहाँ दिया है.
हाउ इट हैज बीन डेल्ट विद, इसमें तो कुछ भी नहीं किया है इन्होंने डील श्रम आयुक्त ने.
सर ये ऑर्डर रिफरेंस होकर ऑर्डर जाता है, बस जो लेबर कमिश्नर दोनों का एविडेंस, दोनों के जो बातें लिख के वो लेबर कमिश्नर के पास भेजता है, देन उसको देख के वो ऑर्डर फिक्स करता है. तो इन्हें जो ओरिजिनल फाइल है उसमें केवल ये जो रेफरेंस आया है वो इन्हें पेश किया है. जो जो वहाँ की जो प्रोसीजर है वो इसमें नहीं है सर, कि जिसको देख के लिखा है कि जिसने एप्लीकेशन गया, इनका रिप्लाई गया, देन उसका जो भी कंटेंट दोनों का समझौते की पूरी प्रोसीडिंग आता है, देन उसके बाद वो ऑर्डर करता है.
यस, और कुछ बहस करनी है आप?
सर ये दो जजमेंट जो रिलाई कर रहे थे,
आई विल कंसीडर थर्ड.
I oblige.
इसी में
My lord, may give me liberty, my lord, to supply that judgment.
Yes.
It is a recent judgment, my lord. I will mark that paragraph by the division bench. Oblige.
और वो सर कमिश्नर वाला अथॉरिटी अगर लेटर मिल जाता है, कोई नोटिफिकेशन या जिसमें उनको अथॉरिटी है कि कमिश्नर ही लेबर कमिश्नर कैंसिलेशन करके रिफरेंस पेश करेगा.
आप एक आपको कॉपी दे करके
हाँ मैं दे दूँगा.